Hello, friends. I'm Jared Smith, the Associate Director of WebAIM. In March of 2019, I presented at the first Digital Accessibility Legal Summit about the future of digital accessibility in the law. My presentation featured answers to a variety of questions from several colleagues that presented at that summit. I considered them all much better versed in the digital accessibility legal landscape than I. I summarized our collective thoughts about what the future might hold. Chris has asked that I present a brief update on how things went over the last 2.5 years and how the legal environment might pan out in the future. I began my presentation 30 months ago telling about my 4-year-old son having a particularly rough day. When I asked him what was wrong, he teared up and responded in an exasperated tone, "I'm just trying to survive." I expressed at that legal summit that many of us in the accessibility field feel exactly that way. We're doing all we can to bring about digital equity, and that often feels like an uphill battle. Little did I know at the time that "I'm just trying to survive" would become my personal mantra as a global pandemic disrupted our field and the entire world. I so appreciate the ongoing and tireless efforts of all of you to realize our goal of true equal access to digital content. But are we making a difference? 2.5 years ago, I stated that awareness is not enough for us to be successful. There must be more and more effective action. If there is anything positive that has come from the pandemic, I think it is that a new light has been shown on the inequities of digital access to critical information and functionality. Awareness is increasing, and so is action. Over the last year, WebAIM has revealed significant accessibility barriers to COVID information and vaccine websites. Bringing this to light brought about changes by the federal government and by many state websites to improve accessibility for the disabled to these critical resources. The WebAIM Million analysis of the homepages for the top 1 million websites has found significant barriers to users with disabilities, an average of 52 detectable WCAG failures on the average homepage. This number, however, has decreased from 60 detectable failures just a year prior. Perhaps being more aware of these barriers has affected a bit of change. I believe, and I'm hopeful, that this trend of slow improvement will continue. 2 years ago, our panelists nearly unanimously expressed the criticality of technical standards such as WCAG 2 being defined for digital content under the ADA. But they also indicated that they would prefer that issue be addressed under a different administration. The current administration has subtly hinted that we may see a renewal of this effort, at least for Title II entities, but I'm not aware of any firm plans. The Online Accessibility Act, which would have defined a new Title IV under the ADA to specifically address digital accessibility barriers, has gained little traction. While we certainly need better clarity on the applicability of technical standards under the ADA for both public and private entities, I do not foresee notable action on this occurring until it is forced by a unified support of disability rights advocates and organizations. Of course, even in the absence of administrative clarity under the ADA, the complaints and lawsuits continue. When I asked our legal experts 2 years ago if they expected the trend of increased demand letters and lawsuits to continue, they all emphatically responded yes. We have, of course, seen that trend continue and even accelerate. I've heard it said that litigation is the basic legal right which guarantees every corporation their decade in court. The legal environment moves slowly by design. I frankly foresee few landmark changes in this landscape in the coming years. I've suggested that one driving factor for the increase in litigation has been the sense by many in the disability community that suing has been the only avenue for them to demand the access they need. As I look to the future, we need administrative processes for filing federal discrimination complaints and state complaints that are friendlier to those disadvantaged than those that are placing them at a disadvantage. What can we do to ensure that happens? When I look and consider the future of the digital accessibility field, I'm invigorated by the new voices of young people joining our ranks. More people are engaged in making the web more accessible. So back to my question, are we making a difference? I believe that we are. The most important question that WebAIM regularly asks on its surveys of users with disabilities is regarding their feelings about web accessibility progress over the previous year. In our most recent survey of screen reader users, 39% indicated that the web had become more accessible, compared to 19% that thought it had become less accessible. While the pace sometimes seems glacial, and I sometimes feel like we're just trying to survive, I know and those with disabilities indicate that good things are happening. As I look to the future, I see a future that is bright. Thank you.